Good morning and welcome everyone, those of you who are here in person and those of you who are calling in and watching on the web. We would like to welcome you to our Hull and Hull Breakfast Series. Today's topic is entitled The Moment of Death and Beyond, Preliminary Duties of the Estate Trustee. We hope that you'll enjoy this. We have an interesting group today because we have a special guest who's going to be joining us today. His name is Robert Turner, and Robert is a funeral director with the firm of Cattle, Eaton and Chambers. This funeral home is located in Dundas, and I think that explains why Robert hasn't had a chance yet to join us. So once he does arrive, he will be joining and participating in our discussion. Also speaking today, I'm very pleased to announce our Ian Hull and Moira Vishayu from our firm, and we're looking forward to an active discussion. We wanted to start just by introducing some of the other members of our firm who are here with us today. We've got our partner David Smith, Paul Trudell, and our associates Jonathan Cappy, Crystal O'Donnell, one of our newest lawyers, Stuart Clark, Holly LaValliant, Andrea Bunchick, also one of our newest additions, Noah Weisberg, and Josh Eisen. We're also very pleased to have our clerks join us here today. You met Heather Fritchkowski on your way in. We've also got Christine Mercer, Heather McGuinness, and Jocelyn Martin. You, in addition to meeting Heather at the front, met our office manager, Diane LeBow. And we're also pleased to have our articling students join us here today. We've got Reese Newman, Michelle Kotzer, and Nick Esterbauer. And so with that cast of characters, I'd like to turn it over to Ian Hull to introduce our discussion.
Well, thanks so much, Susanna, and we will see how this flows today. We, in trying to pull together these programs, there's two sort of primary goals. One is to keep a focus on a solicitor's practice in issues that we are faced with day-to-day on day-to-day administration issues. And secondly, we want to keep a component of our ethics expectations for the Law Society, so we're going to cover some of those, particularly some of the rules of conduct that apply. I said two, there's a third component in this one, and that was that we thought about this issue, and we in our practice, we struggle with the whole question of the sort of first, there's a great show on A&E called 48 Hours that talks about the first 48 hours, the best 48 hours of a murder investigation are the first 48 hours. Well, this is sort of the first 48 hours for us to talk a little bit about what happens on that instant of death and the expectations of the estate trustees, some of the problems that we run into, so we're going to cover those off, and if everything works out, we're going to hear from Robert on the sort of day-to-day, truly particularized elements of being dealing with the body, because his profession being a funeral director, but we'll see how the traffic unfolds on that one. So let's start with Susanna. We have our handy-dandy system here for interactive questions. I hope people picked up their little gadgets to vote. So, Susanna?
So we're going to start with our first question. Who has possession rights with respect to a dead body? Is it the surviving spouse, the next of kin, an estate trustee named in a will, or the power of attorney for personal care? If you could choose your answer. As you know, these answers are completely anonymous, so you don't have to feel any pressure to be right. Okay, so we've got a couple of responses. We'll just close polling in a few seconds. Okay. And so we've got 74% of people say that it's the estate trustee.
So we started with this question for a reason, and that was the sort of starting point of any analysis, the immediate after death issues. Some people deal with this issue as solicitors and as friends of the family, but ultimately the substantive position the estate trustee has possession rights with respect to the body is very important if we're getting into contentious situations, and we're going to talk about some of those contentious situations. So that's a starting point. Interestingly, the wife, the surviving spouse, and family members do not have priority. So what we wanted to do now is we're going to turn to and ask Moira to speak on a unique element of the obligations of an estate trustee and some of the interesting substantive issues that arise out of the what I'll let her describe, the unique way of dealing with the body after death as opposed to the classic burial scenarios. So Moira, can you talk to us a little bit about that?
Sure, Ian. Hello, good morning. I'm here to talk to you, as Ian said, about a very unique and unconventional kind of estate plan and a very different kind of 48 hours, but a very urgent 48 hours nonetheless. I'm here to talk to you about cryonics. Cryonics is the speculative practice of preserving a human body in extreme cold temperatures for decades or centuries, with the ultimate goal that it might one day be able to be revived. This is so unconventional that there are currently only 200 people that are cryopreserved since 1967, but it's becoming an increasing trend, and there are 2,000 people that are currently signed up for membership. There are 2 cryonics facilities in the world basically taking new members. One is in Alcor in Arizona, and the other is the Cryonics Institute in Michigan. The members that sign up for these arrangements sign forms and agreements with Alcor and either prepay for the preservation or they'll buy life insurance and designate that organization as their beneficiary. And the costs can range from $40,000 on small and low end to $250,000 on the high end. So obviously this is a very unique and different way of planning for the disposition of your body, but it creates all sorts of interesting legal challenges for those 48 hours. I'm going to go into a bit about the process for suspension because that'll help you understand the unique challenges. Even though no one has ever been brought back to life from cryopreservation, there are good preservations and bad preservations. And a good preservation is one that minimizes the damage to the human tissue. So in order to get a good preservation, basically a cryonics team of like 4 or 5 people have to be able to immediately start the process upon legal death. And so if that person is in a hospital and they're surrounded by family members who don't necessarily agree with their wish to be cryogenically preserved, there can obviously be issues and interference. The team has to immediately plunge that person into an ice bath and start them on a heart-lung resuscitator or a thumper machine. They also have to start an IV and pump various medicines and chemicals into their body. Each of these processes are designed to keep oxygen flowing to the brain and to prevent tissue damage. But obviously that's very invasive, and so if that team of people were coming into your home or coming into the hospital and proper arrangements weren't made, it's easy to see how that could go terribly wrong. Every moment that the human body is warm and is not receiving blood flow or oxygen to the brain results in significant tissue damage. So that's why it's so important that these things happen properly and smoothly. Ultimately, with cryonics, it's not about whether you can win a battle in a courtroom, because if you've gotten that far, the chances of successful preservation are almost zero. The point is that you have to have the paperwork and the documents and legislation to back it up so that the people have the sufficient authority to come over and take over control of your body and do what they need to do. Once the team has stabilized your body, they transport it to the appropriate facility where it's stored in liquid nitrogen indefinitely at a temperature of negative 196 degrees. So how can someone who has this unique estate plan make sure that their wishes are respected? It goes back to common law. The executor has the power to determine how a body is interned, and if there's no executor, then it goes to the next of kin. The duty of an estate trustee with respect to the disposition of the body was established by the common law, and there is no legal obligation on an estate trustee to honor the testator's wishes as set out in their will. The only duty is that they have to provide a burial or interment that is befitting one's station in life, which is a Supreme Court of Canada case from 1953. However, that common law has been modified in various jurisdictions, so in BC and Quebec, there is legislation that was enacted that provides for a duty on the estate trustee to exercise that discretion in accordance with any written wishes of the deceased, unless that to do so would be unreasonable, impracticable, or cause hardship. And Quebec has similar provisions. In the U.S., about 9 states have enacted similar provisions with respect to that obligation, and also have different varying words for the exceptions. The problem with this is that even if you were in one of those jurisdictions where there is a legal obligation, it's pretty easy to see how an estate trustee could argue that complying with your cryonics wish is unreasonable or causes hardship or is impracticable because of the significant work involved. And often wills are just simply read too late in the day to really be helpful in those first few minutes. So another key piece of legislation that cryonicists are relying on started in the U.S. called the Uniform Anatomical Gift Act. It has since been revised. The key provision provides that an anatomical gift may be made to the persons named in the document of gift, including a hospital, accredited medical school, dental school, college or university, organ procurement organization, or other appropriate person for research or education. Now, clearly, the intention behind this was to promote the organ donation for transplantation, but there's also a clear secondary purpose, which is to provide for the donation of the body for research and medical and scientific research. There's a leading case in Iowa called Alcor and Richardson that deals with the application of this act to the cryonics situation. In that case, brother and sister estate trustees of the deceased were well aware that the deceased wanted to be cryonically preserved, and were well aware that he had made arrangements with Alcor, including prepaying $50,000 of the total fees. Upon his death, however, they ignored his wishes and had him embalmed and buried. They later wrote to Alcor and requested a reimbursement of the $50,000 that he had paid for his cryopreservation. When Alcor found out, they immediately sought a mandatory injunction requiring the siblings to disinter the body so that it could be frozen in accordance with his wishes. Alcor lost at trial, but appealed and won on the appeal. The Court of Appeal looked at the applicability of the Anatomical Gift Act to the situation. Specifically, it looked at whether Alcor qualified as under one of the enumerated types of categories. It didn't qualify as a university or an organ procurement agency, which has to be designated, but it concluded that it was genuinely engaged in scientific research in the area of cryopreservation, and as such, it was an other person engaged in research. It also spent some time looking at whether this qualified as a gift, since under the Act it refers to anatomical gifts, and it decided that the contractual nature of the arrangement did not disqualify it from being a gift. Ultimately, the court did order that the body was disinterred and that the deceased wishes be carried out. However, obviously, given the length of time that had passed, any potential for future reanimation is almost certainly none. But it does create an excellent precedent for cryonics organizations to be able to rely on these kinds of consents. Most provinces in Canada have adopted similar legislation. In Ontario, the Act is the Trillium Gift of Life Network Act, named after the provincial organ procurement organization. It doesn't refer to a gift in the Act. It just simply says that any person who is 16 years of age can consent to their body being used for therapeutic purposes, medical education, or scientific research. It goes on to say that the consent is binding and full authority for the use of the body, except that no person can use that consent if they have reason to believe it has been subsequently withdrawn. In BC, the Human Tissue Gift Act goes further and states that a statutorily valid consent prevails over any intention in the will or any other contract. In Alberta, the equivalent legislation limits the organizations to universities with a medical, dental, or health program. So a cryonics organization could not rely on that, could not rely on a consent in Alberta for that purpose. Also in Alberta, again, the estate trustee has no legal obligation to respect the person's wishes with respect to disposition. So as a friend of mine has said, if you're a cryonicist and you live in Alberta, you may want to consider relocating. These are broadly worded provisions. They allow the organization to step in and take over control of the body. So it's very powerful legislation for cryonicists to use. And I think it's much better than relying on the estate trustee. The other risks to successful preservation is one act that trumps them all, whether you have a consent or declaration in your will, and that's the Coroner's Act of Ontario. The Coroner's Act of Ontario prescribes which cases are to be reported to a coroner, and they're very broad. They include things like if a person dies by unfair means during pregnancy, suddenly and unexpectedly, or from any cause other than disease. And there are also prescribed situations in which an autopsy must be performed, such as if it's on the job or during childbirth. There are 90,000 deaths every year in Ontario, and about 16,000 of them are reported to the coroner. So since you understand how important seconds and moments are after the person's pronounced dead, even just having to deal with the coroner at all in this situation is devastating for a good cryopreservation, and we want to avoid it as much as possible. In the States, 5 states have enacted a religious objection to autopsy legislation. We do not have that in Canada, and even in the States, it still can be overridden in the case of homicide or where the public interest is a concern. So ultimately, at the end of the day, any legal contest over the body is disastrous for a proper cryopreservation, and so we want to just try to avoid that as much as possible and increase the legal recognition of a person's right to determine how they want to dispose of their body. There are only about 100 people in Canada signed up for cryonics, so chances of you running across someone who wants to do an estate plan such as that is low, but if you have any questions, feel free to contact me in the future.
All right, so just talking about a unique element of dealing with the body, now that we have our star and our guest of honor, and we're going to now put the microphone over to you a little bit and throw some questions around. But the next question leads us into and follows up with the kinds of issues that Moira has started to talk about, and that is some of the conventional perpetual care issues that arise. I've had the pleasure of being down in Eastern Ontario and Western Ontario on 2 cases where we were fighting over perpetual care issues. And they can be interesting because, of course, the longevity of these cemeteries that were created back in the 1800s being funded is sometimes a problem, and issues arise out of that. But let's ask the next question, and then we can start teasing that out, and then also look to the real death questions.
So our question is, who is the most appropriate defendant to an action commenced by an individual who's injured by a broken gravestone? Is it the cemetery owner, the estate of the deceased, an estate trustee, or the estate's beneficiaries?
So as you're doing the answers to this, you can see that the personal injury bar will not be jumping all over this kind of work, but you never know. If some of you have seen the Steve Stavros monument coming into the Mount Pleasant Cemetery, if it fell on someone, that would be worthy of probably a monument right beside it, because it's gigantic. But most monuments aren't, or maybe breaking a leg or something. But Robert will know more about that, because he's probably seen the odd monument fall and or heard about this issue. But why don't we just plug away at the answers?
Okay, we're going to close polling in a few seconds. Okay. Or not. And we have no responses. Technical difficulties.
It's going well so far. All right, well, this just enters into the really important question of ownership of these of a perpetual grave site. And the rights of ownership are interesting in the sense that the cemetery owner retains title to the land, and pursuant to the Cemeteries Act is responsible for all its upkeep. So a cemetery is required in Ontario to keep its facility, so to speak, and crematorium of the property in quiet and good order. So, Robert, over to you on what quiet and good order means, certainly in the context of a crematorium, but in the context of what you're seeing on your day-to-day practice, and are you seeing these kinds of issues arising? Oh, we got some answers here. This is great. So the cemetery owner, great. This is a group of people that know death well. Robert, do you have any thoughts on this issue?
I don't. Other than any cemetery who takes prepaid funds has to put a portion of that towards a perpetual care and maintenance fund. So the idea of that is if a cemetery becomes closed in the future, there'd still be funds to maintain cutting the grass, fixing stones, stuff like that. You'll see, maybe not here in the big metropolis of Toronto, but where I'm from, a little town of Dundas, there's a lot of little small cemeteries that it could have been on a family farm at one time, may have 5 or 6 stones on it, but the weeds are, 3 feet tall in that cemetery. So I think the government's idea behind that was to make it so those kind of cemeteries could be maintained in the future, and we don't have these eyesores or eventually become so dilapidated that they become unsafe. They're talking about the headstone falling over. So,
And that's the key is that where from time to time the litigation that arises is these municipalities are being expected to take over the cemetery because the perpetual care funding isn't there, and then we get into a dust-up over that and who should be funding and so on. So, all right, let's now that we've got Robert here, we've got our next question sort of enters us into an area where he would be, I guess, faced on the front line with this. When someone, which question? Oh,
This is the
sorry,
wrong
we
question.
jumped too far.
There we go.
You go.
Okay, so our next question is, what must an estate trustee do to satisfy his or duty with respect to the disposition of remains of the deceased? Do they have to act reasonably, dispose of the body in a dignified manner, comply with the wishes of the deceased, or consult the deceased's family?
Robert, when you, in your practice, you must see all of the time some unique requests for the treatment of the body, not just chirogenics or those sorts of unique things, but just expectations. There's a case in here that we talk about, the Sapinka and Sapinka case, which the family fought over the wife wanting to put the son's remains in with her husband's remains right in the same casket, and those kind of spicy situations were litigated over. What sort of issues do you see arising at that moment when the high emotions are there and you're sort of trying to fend them off and hold the family together a little bit?
right. Well, I mean, there's really, there's nothing we can do. We have to take all our direction from the executor. So if there's a will, the executor calls the shots, regardless of what you have on paper. If you've paid for something ahead of time, your executor calls all your shots. So if they want to bury somebody standing straight up and down, I mean, legally they can do that as long as it's okay with the cemetery. But, there's really, we're tied to whatever they want.
Do you get a few of those requests?
No, not yet.
And
No, we
how
didn't yet.
often, Robert, how often do religious considerations cause problems in your experience?
Well, not very often, unless sometimes with a blended family, where maybe the new spouse has a religion that's different than the kids or the previous family. It doesn't get too ugly, but you can get into some situations. Jehovah's Witness, we had one not long ago where this fellow had married into a Jehovah's Witness family, and the previous family certainly wasn't aware of any of that, and it got nasty.
So what's our answers coming out at?
So, polling is closed. And we've got 40% suggest that the answer is dispose of the body in a dignified manner. And that's, of course, the right answer. And legally, we heard practically that these issues arise, but certainly from a legal perspective, that's one of the minimums that's expected of an executor, and that is that the body is disposed of with dignity and in accordance with that individual station in life when we're talking about how much are we spending on making sure that someone's properly taken care of with dignity.
So dignified manner is the test. Robert, you just said that obviously taking the instructions from the executor, we've already established that they have control. In a situation without a will, you must run into those scenarios. We'll talk a little bit about the law, but what are you finding in your practice in terms of day-to-day? When they don't have a will, how are you managing that?
Well, it sort of depends on who's still around, right? If there's a spouse, I mean, it's pretty easy. The law states that if there's no executor, then it goes to the spouse, and then adult children, and there's a whole chain of command of who can make those decisions. So again, it seems to be we run into most of our problems when there's been a blending of families, two families together, a stepmother or stepfather, whatever it may be, and those two sides may have some animosity prior to the death. There may not be, but it certainly all seems to come out in our office in a quick hurry. So,
Yeah, and Robert, you're, just from a substantive standpoint, the Section 29 of the Estates Act talks about where the will does not name an estate trustee, the court has discretion to appoint a spouse or common law partner of the deceased, next of kin, or the partner of the next of kin. And then it sets out generally the food chain, so spouse, adult children, grandchildren, great-grandchildren. Where there's no spouse, there's no issue, then you start talking about going up the chain, parents, siblings, and it actually tracks the intestacy patterns. So I've certainly been involved with contentious litigation where we have been fighting over who should dispose of the body, and that, you know, when you get in a situation where the spouse is estranged, or and the family wants to play a more direct role. So you can see contentious litigation coming out of that. As I said, the Sapinka case talked a little bit about that, and the other case that we put in the paper, Buswa decision, talked about two estate trustees where the siblings and the daughter were fighting, and this is what Section 29 of the Estates Act allows for, well, mercifully allows for fighting, but allows the court's discretion. In that case, the siblings insisted on the burial being done in accordance with the nation's religious rites. This was a First Nation burial situation, and the deceased daughter said no, that the deceased didn't want to abide by those, never wanted to abide by those. The deceased, they went to battle at it, and they sought an appointment of a state trustee. Of course, the daughter did, and she succeeded because she was the closest next of kin under the Estates Act, and the court looked at things like the dignified manner test and the food chain that's established under the Act and common law, which is all referred to in the paper. So that was how that scenario got broken up, and you can imagine in situations where there might have been a question of, I've been involved with cases where the surviving spouse is involved with abuse claims or allegations, and the family doesn't want the surviving spouse involved at all, so you get into a contentious, under Section 29 of the Act, fight.
And that whole issue of the fight over the body, as crass as it sounds, is one of my favorite ones, just because it was the very first case that I worked on when I joined Hull & Hull. And so I've got a near and dear spot in my heart for that. Robert, I'm wondering, from your perspective, we love the fights, because of course that means we're very busy lawyers, but what happens, practically speaking, to the body until you've got some comfort in terms of knowing who you can take instructions from?
right. Well, nothing really. We generally have to wait till we have somebody in charge to give us direction. Because if something went south, and we're licensed by the Ontario government, the Board of Funeral Services, they would come down on us. We had a case not long ago where there was a fella here, and his only surviving relative was in Germany, and only spoke German, didn't speak any English. I contacted our Board of Funeral Services to see what, he had a close friend here who was willing to do it, but the Board of Funeral Services said, no, unless you talk to this brother and get his permission for what you do, if he has an issue with what you do, then we're coming to you. So, yeah, so for 3 or 4 days we had to, find an interpreter and contact Germany, talk to the brother, get his okay with everything that the friend had situated, and send us a fax, and then the friend could make the arrangements. So yeah, so it can be certainly a big delay, and especially if they're trying to get a trustee or somebody done in court. That's certainly not an overnight process. So it's yeah. So
I use the litmus test. There's always at least one set of ashes in our office at some time, so there's a good fight over ashes. We have a little special spot for it. It's fireproof, of course. All right, Rule 2.01, of course, deals with the rules of professional conduct, deals with the competency, and Rule 2.01(1)D talks about timely and efficient communications at all stages, and I think we've already heard of the necessity for the executors to, in a contentious situation, step in immediately and instantly. That's the that's the jurisdiction they have, and we're obligated to make sure that our clients understand that we're efficiently communicating that to our clients. In some cases, it's often a good idea to really talk through some of these general issues before death. And one identifiable issue that I've used to track these kinds of immediate death potential problems is, I've talked a little bit about organ donation when you're taking will instructions. That allows you to open the door, A, to a very important cause, which is the fact that Ontario has a very low percentage of organ donators. It used to be we put them on the card, and now it's just a simple, you have to go on the web and just simply donate, confirm that you'll donate your organs on the web. But organ donation is an interesting intake step. Then you can start to say, okay, look, those are immediate steps. I mean, cryogenics may not be the first thing on top of people's minds, but immediate steps have to be taken for organ donation. So it gives me a chance to say, okay, now, just so you know, this is the sorts of things your executor is going to have to do quick. And if there's going to be a fight here, and you already know there's going to be a fight, these issues need to be, I like to cover them before death with the deceased, who then should have the chance to talk to their appointed executor. And the organ donation program, the Trillium Gift for Life, it's an Ontario government-sponsored program, actually very easy to donate on, is a great way to segue into that.
And I think just from a practice management standpoint, it's something that I've added to my checklist, in the sense that you want to have these discussions, but you also want to use it as an opportunity to really clarify with your clients that organ donation intentions are not binding at the end of the day. So you can indicate that you want that to happen, but practically speaking, when that decision is being made whether or not something's going to be donated, or tissues or organs, the actual people who are administering these programs, if there's any fight at all between the executor and family members, they're not going to do anything. And so despite all of your best wishes or your intentions to be upheld, they may not be. So that's another important thing that I think I try to remember to tell my clients, that communication really is the key. You want to let the people who are going to ultimately be making these decisions on your behalf really know and understand that this is what you want. And
it's really a situation where, you know, from my perspective anyway, the possibility of a dispute over that issue being put in the hands of, it's as we know, everything's precatory. The executor has control over the body and has control over the decisions. All of these things, though, can be anything we can do to give some telegraph, some messaging through either in the will or through the organ donation steps, gives the executor some guidance, which is, again, what you really want to do, and that is give them if you want things to happen, give them the best message you can, and if it can't happen, it's going to not happen for good reasons. So these are all situations, Robert, when we've got a healthy, well-paid and well-funded estate. Our next question sort of teases out the situation where we aren't exactly flush. So, Susanna? So who might pay the cost of a funeral when the estate is insolvent? Is it the creditors of the estate, the City of Toronto, an estate trustee, or all of the above? Well, we've got some good responses, so we're going to close polling soon. Okay. And we've got most people saying that it's the City of Toronto. All right, so before we come to the answer, Robert, that's a delicate situation for you, obviously. You're in the business of making sure that you're getting paid for your services as well. When you get in a circumstance where you know clearly, or you've got a pretty good idea that this is going to be a very modest circumstance for the person, the family, what do you do at your office to manage that?
Well, in this case, the City of Toronto, Ontario Works, they have a burial program. So for people who can't afford a funeral, they will pay for a basic service. It's certainly nothing that's super elaborate, but respectable. And in the case of cremation, they certainly pay for all that. In the case of burial, they pay for a very basic cloth-covered casket. And there's some, in Hamilton anyway, there's some limiting factors of what they can have. They can have a 2-hour period of visitation. They get this cloth-covered casket. They're not supposed to upgrade anything from there because technically they don't have any money. Does that happen? I'm sure it does. I'm in a little small town just outside of Hamilton, so we don't dive into that a lot. We do get a few here and there. Now, what most people don't realize is that the city will actually try to recoup their costs from the Canada Pension. So if somebody worked, as soon as they apply for the Ontario Works or the municipality to pay for the funeral, they'll immediately close off any death certificates. The family will get no death certificates, no Canada Pension documents, and they'll make an application and try to recoup whatever cost they can out of that. So that doesn't prohibit the spouse or surviving children to make an application, but it certainly does not allow the death benefit of a maximum of $2,500 to be paid out to the estate. They try to recoup their costs. So really, it's no cost to the city. It's basically the funeral home that takes all the hit on that.
I didn't realize that they went and chased the CPP. That's good. They're as good as any collector. I noticed, of course, which is sort of the two things I've ever only remember about this substantively is one is that the executor controls the body. The second is that funeral costs, well, actually, I like to say it this way, compensation and funeral costs are first charge against an estate. And so that helps us, too, from a standpoint of the administration. An insolvent estate, even if it's got enough money to sort of get the body in the ground, is often the test. Robert, one of the things that we see a little bit of, but I'm curious because I didn't know this statistic, but there's over $2 billion of prepaid funeral service contracts in Ontario right now, approximately, with 40% held in cash and trust and over 60% funded by life insurance proceeds. What do you find in your practice? Is this a growing trend, or is it sort of a steady, sort of certain group of individuals continue to sort of prepay their plan? And and secondly, does this cause a headache for you? Do you have to manage that money, or how does it trust money's held?
Right. I would say I've been in the business 24 years, and I would say that over the last 15, it's pretty evened out as far as people who prepay and don't. There's no disadvantage to us whatsoever. Whoever you use will hold a trust account, similar as to you folks have your trust accounts. It's similar to that. We hold ours with a bank that has its own prepaid funeral department. So full reports, all that, everything's individualized. The GIC is individual to each person that prepays, bears interest, and that kind of system. So, and we have to report that to our board once a year. So
where does your interest go? Ours goes to the Law Society. So.
Yeah. Ours is totally funded into itself. So
right.
It just keeps growing and growing and growing. The idea is that it keeps up with or ahead of any increases that we see. Any excess funds go directly back to the estate.
Do individual homes price that, or is it a sort of across-the-board pricing for the prepaid? Are there plans you go into? How does it work for the prepaid? Like if I come in and I say I want to do a prepaid, what is it? Am I buying a plan through some insurance company, or am I buying it through the home, or how does it work?
Yeah, you can do an insurance policy. We don't where I am. There's some limitations on if you want to cash it out ahead of and just and move. Where ours is fully cashable. So if you prepay with us and decide to live in Florida or out west, it's a simple check. Where the insurance, it doesn't quite pay out that way. Yeah. So you pay $6,000 and then they offer you $3,000 when you want to move, kind of thing. So we don't offer insurance just for that reason. We like people to have their own flexibility. So, and it's a 50-50 thing. Now, what would happen is people go into the funeral home, they'll basically arrange their funeral. The funeral director will give them a cost, and at that point, that's the amount that they would pay.
So you have to price it. So you have to judge what it's going to cost in 30 years to bury that person.
Well, no, it would be at today's value. So if you came in today's value, say that the funeral was $6,000, that's what you would prepay, and then that goes into a GIC.
Gotcha.
Bears interest, and then in 30 years it would be worth.
You hope you're investing well.
Yeah, that's right.
No BRIEX for those funeral directors.
No.
All right, well, just on this happy note of insolvency, the other area, the third component that is sort of fundamental to any estate trustee is advertising for creditors. We deal with it in our paper, but the key here is, of course, the advertising allows for some fundamental protections to the executor if you follow the right steps. Why don't we go to our next question? And I think hopefully we're talking about creditors. Oh, good.
Yes.
This is working out well.
So the question is, under which of the following circumstances should an advertisement for creditors be made? And and we've got an automatic answer. Number one, the estate trustee wishes to limit personal liability. The estate trustee and sole beneficiary are the same person. If it's not expected that there are any creditors of the estate, or none of the above.
So, Robert, when you, at your home, and maybe because you've got sort of province-wide experience in terms of you work with a lot of directors over the province, what sort of services do you provide people when they come in the door in terms of basic funeral arrangements? Obviously, do you help them with their CPP? Do you ever talk about advertising for creditors or any of that kind of stuff?
No, we have an executor's toolkit, which is put out by somebody in the industry that we give to families. We can cancel the old age security and Canada Pension. We can send them off a fax. That's all fine. But really, that's about our limit to that. We're not, we're not lawyers, so we don't pretend to be, and we don't want to be. We have so many other outfits that we have to wear nowadays that's really the last thing we want to get into. So,
so you guys aren't going to become paralegals of this?
No, I would hope not. So, yeah, no.
What about the fight for the death certificate? You must get caught in the middle of those, and of course we've got two sources. One is from your home,
right,
which is crucial when we've got insurance policies or anything like that. We want to get that to the insurance company quickly and steal that money back that they've stolen from us for over 50 years. And then the second is, of course, the question of just applying through the Government of Ontario. The standard application takes, Heather, what, 4 to 6 months? How fast do we get a death certificate if we do it through Ontario?
Within a week to pay extra.
Oh, we got a fast wait. This is great. So if you pay extra, we can get an Ontario certificate quickly. So how about you? Do you get caught in the middle of the issuance of the death certificate? Well, this, I think we're almost, we'll come back to the question. Let's think about the death certificate fight.
Well, yeah, this is the brilliance of our government, because we cannot issue a death certificate to anybody but the executor. But anybody can apply for a death certificate through the government, right? If you want to pay that fee, there's a form, you fill it out, bang, you get a death certificate. So, where their thought process is on that, but I'm not sure. So, yeah, we have to be very careful of who we give that to. It can be fairly dangerous, especially in the case of Canada Pension. They can make an application and falsify that they were responsible for the funeral. We're not talking about lots of money, but $2,500. So yeah, we have to be very careful. And our number one reason that funeral directors lose their license for a time or are penalized are almost through giving ashes to the wrong person in the estate and issuing a death certificate to the wrong person.
Well, if anyone need anyone to hold ashes, we're good at that. Okay.
Yeah, that's right.
All right. Let's see what the answers are. Over to you, Susanna. All right.
79% said that the estate trustee wishes to limit personal liability, and that's right.
All right. So the next question, which number? What are we at? Number? Yeah. What is the effect of probate? Oh yeah. Go ahead.
Okay. So what is the effect of the granting of probate with respect to an estate? Is it that the court recognizes the appointment of the estate trustees? Is it a confirmation of the validity of the will? Is it that the certificate of appointment is produced? Or is it all of the above?
This question is just being asked to see if everyone's awake. This is pretty straightforward. Well, we could move through this one fairly quickly, but it ties into our next one nicely because we'll let it just go. Okay, let's close the polling on that one.
So 81% said that it's all of the above. So everyone's awake.
All right, so the next question.
Do the wishes of the deceased have any effect on the performance of an autopsy? Yes, no, or unsure?
All right, let's talk, Robert, while you're getting some water organized here. The whole uncomfortable scenario where we've heard a little bit from Moira about autopsies in the coroner's office not being involved very often statistically with most deaths anyway. What about in your practice? Do you see the autopsy issue arising, and how does it affect your sort of role in the process?
Well, I would say that autopsy is it's not super common, but when a coroner is doing an inquest into a death, and he decides that there's going to be he or she decides that there's going to be an autopsy. It doesn't matter what religion, what your family want, what you don't want. If he says yes, it's happening. So now I'm sure their funding has been cut back a bit too. So if there's any kind of, they can think about, figure it out maybe what had happened. They're probably less than they used to. Certainly from when I started to now, the rate of autopsy bodies coming to us are much less than they used to be. So I'm assuming that's a funding thing for them.
And the way a coroner, and that's all tied to we've got in the paper, the Coroners Act, it sets out situations where, circumstances where an autopsy may be sought, violence, misadventure, negligence, malpractice, so on. The list is there. With regard to the frequency of autopsies, it's true, though, isn't it, that first of all, in smaller communities, and we have a coroner here, but we have deputy coroners, but in a smaller community, local doctors can take on the role of coroner for the purposes of the on-site inspection of the body in some situations. Is that right?
Yeah, well, they're all doctors.
Yeah.
We have, I think, 4 in the Hamilton area. And one's a GP who switched over to a psychiatrist. Another is, a doctor for children, and so they definitely do have a doctor background. In other provinces, it's not that way. We dealt with a coroner in BC. And had no medical history whatsoever. It's just so we weren't sure.
So the coroners obviously are as I say, the maybe spicy situations where you have violence.
The system has detected that a few lines are still connected to the conference and will attempt to end it. If you wish for the lines to remain connected, please press any key.
All good. Now tell me, Robert, with regard, though, to a situation where you have to attend to retrieve the body, right. Would you be typically involved in a car accident situation or off-site? I mean, obviously hospitals are one thing, but off-site hospitals, what role does your office have in that regard?
Right. Yeah, we would generally always pick up from the hospital or a home, but if there's any kind of a coroner's inquest, the body would go to the forensic lab. In our case, it's Hamilton General. And then the coroner and pathologist would do whatever they needed to do, determine, or be happy at least that they have all the information they need to get to the bottom, whatever the case may be, and then at that point they would release the body to us.
So at a conventional death, so to speak, situation, someone passes away in their home, in their bed, what role does you have in that process?
Well, that's different, yeah.
Yep.
Then a family doctor would come, and basically it doesn't matter where somebody passes away until there's a death certificate, we can't touch the body. So generally if it's expected at home, there'd be some contact with the family doctor would come and pronounce the person deceased, at which time the family could phone the funeral home, and then the funeral home would go directly to the home, or wherever it may be. I mean, it doesn't have to be in the house, a nursing home, hospital, wherever. So,
what's our numbers on this one?
You've got 79% say that it's no.
all right.
And that is as a result of the Coroners Act, in which, of course, we're really looking back at Rule 2, which gets us to focus on our competency, and Rule 2.02, where we have situations where we have a client under disability. We have to be much more vigilant in terms of our communication skills. 2.026.1 talks about the situation of the multiple retainers, which of course arises when we have situations where we've got the executor coming to see us and family members who are different. Who are we acting for in that scenario? So it's, as we say, we have to properly delineate the retainer. And lastly, 2.03, which insists on the question of confidentiality, which lawyers are, of course, well tuned to, but of course, in your profession, you are also equally cloaked with tremendous confidentiality expectations.
Privacy, yes, for sure.
All right, next question.
Is it illegal to scatter cremated human remains? Sorry, it is illegal to scatter cremated human remains. Is that true? Is that false? Or are we not sure?
All right, so Robert, you must get this question from time to time, and that is, of course, the idea that they want to go scatter their ashes over, probably up at Queen's Park would be a first choice for a lot of people.
Yeah, absolutely. That is something that we do see quite a bit. So, I mean, if people want to take them up to their cottage on their own private property, fine. You can do it. Keeping in mind that 25 years down the road, you have no right to go back to there if you've sold that property. So, we try to caution people. Does it happen? Absolutely. And it happens a lot. I know of people who have gone over Niagara Falls, and we have a few little falls in our little town that they've gone over, golf course bunkers. I mean, it just Royal Botanical Gardens. I mean, it's almost endless. There's companies out there that put them in shotgun shells, fireworks. You can make a.
That's what we got him here. This
I'm
is
not
the
even
stuff.
kidding.
Tattoos Inc. I heard that they
Yeah,
can use for.
tattoos, yeah. And now there's a coral, like they're making like mini coral reefs out of ashes now too. That I see that's coming out of Florida now. So.
What about the Memorial Diamond?
Yeah, well, again,
Tell us
there you
about
go.
that.
Absolutely. Yeah, I've never seen it. I don't know a lot about it. But yeah, I mean, certainly there's that also. There's people keeping portions in jewelry and all sorts of things. So yeah, I mean, it certainly opens up the avenue for folks once they're cremated. It's pretty hard to do that with a whole body. So,
As we say in our business, that's sort of added value to our service.
yeah, right.
Okay. Illegal scattering. What do people think?
So 54% said it's false.
So it's as Robert says, it's a common misconception. Scattering ash is illegal. There are certain restrictions. We deal with it at page 5 of our paper, and we also talk a little bit about some of the other unique burial scenarios available. So, yes, if it's done right and it's done carefully, you can indeed scatter ashes. So, Susanna, next question.
And I know Moira's alluded to this a little bit, but an individual appointed under a power of attorney for personal care has the authority to make decisions with respect to organ and tissue donation. Is that true, false, or are we not sure?
So, Robert, I spoke briefly about this program, the organ donation program in Ontario. Do you have any, do you find in your practice, do you run into this issue? Do you have to deal with it at all? Do you get calls about this day to day?
Yeah, I mean, certainly we have people who have donated organs, tissue to the Trillium Gift of Life. So and it's very, people are, I think, sometimes are hesitant because they think there's going to be a big delay between, when we get the body because of what they have to do. But really there isn't. They're pretty good. They all have generally a group or a team in each, larger area. So, yeah, certainly it would delay things no more than a couple hours for us. But we're more, we see the cornea, that kind of things, the eyes a lot. But beyond that, it would be hard for us to tell because if they've donated an organ, generally there's been a partial autopsy. And
Right.
If you start counting organs, then you wouldn't know.
Yep.
So,
Yeah, and I guess you guys aren't all that worried about counting organs
No.
at that point? No.
yeah.
I was just guessing on that one. All right, so what are the answers? Let's close the polling. This is specifically section 66, sub 14, and 67 deal with this under the Substitute Decisions Act. The act specifically states that denies an attorney for personal care the authority to make decisions with respect to organ donation. So that's a good statutory reference to the question and the answer. Next question, Susanna, as we start winding up. And just as we're closing up here, we're going to finish for 9:30. We wanted to remind you, of course, that we have chances to ask any questions for sure, and we're going to run out of time. If you want to, at the end of this, we can also deal with questions. So, sorry, Susanna, next question.
Where there is an intestacy, the executor's year commences at the date of death of the deceased. Is that true, false, or are we not sure?
All right. So, Robert, in your practice, you presumably rarely run into situations where you're dealing with the body beyond how long? 72 hours, 8 hours? I mean, you don't have situations really where you're going in having to deal with things farther out than that, would you? Or
Like the body or
yeah,
the funeral?
The funeral. Well, the funeral is one thing. Sorry, the body.
Okay, yeah, a week I would say would be a long time. People travel a lot now, so sometimes getting people back in order, to have a visitation and or service. Now, in the case where somebody's cremated, I mean, we're talking, it's the snowbirds are starting to head down south now. So if mom or dad or whomever passes away now, it's almost can we call you next April kind of thing. So it's so yeah, it sort of really depends.
And do you have issues dealing with getting the body transported cross border and so on?
No, actually, generally it's pretty easy and straightforward. Yeah, we've never had any issues one way or another, really. Yeah.
You haven't. Okay. I certainly run into situations with clients where if someone's passed away in the Caribbean, there have been some delays incurred. But certainly Florida seems to have a direct train up here, so that's.
Yeah.
All right, Susanna, why don't we close the polling?
Trying.
No problem. All right. So the executor's year, that's it's a common law rule, of course, as we know, and that the estate must be administered within the 1 year of death, and that beyond that, the beneficiaries can look to the estate trustees, to the estate anyway, for the accrued interest. It's a breathing space. I deal with the Curry and Curry estate decision that talks a little bit about the trending of the courts, and that is that we cannot expect, the executors cannot unreasonably delay. There's some recent decisions in the past 5 years where the courts have actually insisted that interim distributions be made in the face of an administration. And so we're getting more and more pressure on the back end of administrations now by the courts, certainly, to get the money out and get it out quickly. So it's the executor's year is actually being, in some respects, more respected by the courts, although if you look at these decisions, I sometimes wonder if these guys have ever been executors, because until you get the clear certificate, it's always a dangerous distribution. But that's all right. Judges are entitled to their opinions. All right, what's the answer?
We've got 44% saying true and 56% say it's false, so almost close.
All right. Well, we've got, we deal with the executor's year right in our paper, but it begins at the date of death of the testator and refers to the common law rule. So, the last, is that our last question?
That's our last question.
All right, so that leaves us to now turning to Robert for any anecdotes and interesting stories that your practice has developed over the years. But most importantly, if you have any additional comments on the last part, and that is the urgency that clients expect out of us now in our practice. Email, of course, the curse of all of us, but you must see the same kinds of pressures in your business as well. People want to deal with things quickly, and you have to address it. Probably, if you look back at over your 20 years of experience, the practice of what you do has probably changed dramatically as well.
Well, absolutely. And, there's not the, I don't want to say there's not the respect for a funeral anymore, but it's not an event like it used to be. People don't take time off work like they used to, probably because they can't. We spend a lot of time writing up letters just saying so-and-so was in attendance for so-and-so's funeral on this date and that date, so they can, take a day off work, which, for one reason or another has come about. But again, with the snowbirds, spending so much time in Florida, sometimes it almost feels like the death has become an inconvenience to them because it's cutting into their, golf game in Myrtle Beach or their orange picking season in Florida, whatever it may be. It just, sometimes it just seems like we're the only ones that care anymore. So.
Well, again, and then the Florida stuff is worrisome because it really does affect the flu bugs around March. We're not seeing as many of those. All right, so I think that winds up our time. Susanna, why don't we wind up our, it's almost 9:30, and then we can wait around here and we can deal with questions.
Thank you, Ian. Well, I think really what we can take from this is the importance of the appointment of an executor, choosing someone very wisely to make sure that our wishes are known, respected, and hopefully ultimately implemented at the end of the day. So we want to thank very much our special guest, Robert Turner, and all of you for participating with us today. Reminder, hold that date kind of thing for our next breakfast series, which will be held on Thursday, January the 16th, 2014, and we look forward to having you join us then. Thank you very much, everyone. That's the end of our formal presentation, but we will certainly be around for questions. If anyone would like to pose any questions, feel free to come up to the mics and put those to us. Thank you.
Coming from Dundas, that's, yeah. Well, listen, it was very good of you to come in. No, it was fine.
Excuse me, could I ask a question?
Of
If
course.
the estate has 20,000 in cash, but it owes 60,000, are you telling me that the city of Toronto should pay for the funeral?
It depends. But it depends on who you owe and on what basis you owe it. But the banks, well, look, I mean, insolvent estates are always complex because the priorities get balanced out under the Bankruptcy Act, whether the estate goes bankrupt. The key with an insolvent estate is to advise creditors and to advise anybody who's coming after you that the estate is insolvent. Pleni non administratus is a fundamental principle of law that if we as executors don't announce the insolvency, we create all new problems and we are essentially treated as a solvent estate. So in your situation, you've got banks, if they're secured, unsecured, it depends, but likelihood there is that the priority is going to be the funeral expenses on the estate, but it may depend on the nature of the security they hold.
The executor did notify all of the creditors that it was a bankrupt estate right away, but she paid for the funeral.
Yeah.
Not much, but the cost of actually the
Yeah,
burial.
and that's what the Act provides, and the Bankruptcy Act, if you went bankrupt, also protects you. So it's unlikely that there'd be any problem in that scenario. All right, well, we can informally answer any questions, but thanks again for taking the time.
Thank you.